Good evening, Judge Gorven.
Good evening, Chief Justice and other commissioners.
You've been a High Court judge for how many years now?
7.5 years.
And before then, you were senior counsel?
I was senior counsel at the Pietermaritzburg Bar, yes.
All in all, for how many years have you acted as the Justice of the Supreme Court of Appeal?
I acted for 5 terms, which is 15 months, Chief Justice.
All in all?
All in all.
Yes. And have you acclimatized with the environment, in the environment quite comfortably?
I would like to think so. I've enjoyed it thoroughly, the challenge. I've enjoyed the environment. I've enjoyed the work, and I've enjoyed the colleagues.
And of course, you've enjoyed the colleagues.
Yes, very much so.
And you've been here before.
I was here a year ago,
for
Chief
the
Justice.
SCA.
Yes.
Thank you. Anything you want to add to what we were able to explore with you when you were last here?
I don't think there's much to add. I think with some of the comments that have come, they're very similar to last time. They didn't update the number of judgments that have been reported, but that's a minor thing. Yes. Those have been updated since then in my curriculum vitae. But I don't think there's too much to add unless people want to hear from me.
Yes. President Patti?
Thank you, Chief. Thank you, Chief Justice. Good evening, Judge Gorven.
Good evening, President
I
Patti.
didn't see you earlier.
Yes.
When last did you act in the SCA?
My last term finished on the 30th of September last year.
Last year.
That's
Right.
2015, yes.
And the 15 months was actually one stint of, let's say, 6 months and then extended and then going away and being called again.
Yes. The last time I went away, I was back in KwaZulu-Natal for June of last year, and the need arose to replace Justice Wallace, who'd been called up to the Constitutional Court to act for the coming term. And as a result, I started again, instead of from June, which one normally does, from the 1st of July, because I had to fulfill my duties in KZN before I started my reading for the SCA.
In fact, on one occasion, you had very little time to catch up and read the records. In fact, I think it's this occasion where Judge Wallace was called up to the Constitutional Court.
Yes, I had a month less than everybody else did.
And the judgments that you have written whilst in the SCA, has there been any dissent from them or concurring judgments, separate judgments?
I wrote one concurring judgment for separate reasons, I think at your invitation, President Patti. But for the rest, I've been part of unanimous judgment benches.
Your judgments that you have written have mainly been unanimous, or unanimously concurred in?
Yes, that's correct.
Yes.
There's nobody dissented from any of the judgments that I began to write. Yes, and that I wrote.
Thank you. Otherwise, all the other questions I asked before, and I've got the answers. I'm sure all the other commissioners have the answers. Thank you very much.
Yes, thank you.
Commissioners, anything? Yes, Commissioner Malema.
Yes, on the same note. Now, thank you. Thank you, Chief Justice. What will happen to our democracy if arms of the state were to second guess or deliberately ignore judgments?
What would happen?
To our democracy if arms of the state, judiciary, the executive and legislature were to second guess or deliberately ignore judgments?
Well, I think ultimately there would be a failure of democracy, I believe. I think that all, as a recent judgment said, all public office bearers are subject to the Constitution, and that includes judges. In other words, judges can't go beyond the powers given to them in the Constitution. And of course, it includes the other organs of state, all of them.
Does it include politicians?
Oh, yes.
Does it include ministers?
Yes.
Does it include president?
It includes everybody who lives in our country, Commissioner Malema.
Does it include president?
Yes.
Now, what happens if one of these categories act inconsistent with the Constitution or is in breach of the Constitution? What happens if a judge, a president, a minister, member of parliament, or any South African doesn't uphold, defend, and respect the Constitution?
Then they're subject to a declaration under Section 197 of the Constitution that there has been such a failure, and a court has the discretion to grant further relief relating to that person.
Can a court grant a relief that says this political figure is unfit to hold office on the basis that he failed to uphold, defend, and respect the Constitution?
I would be surprised if a court would ever be in a position where it could go that far. I think the declaration of the situation and the setting aside of any actions taken pursuant to an unlawful use of power are as far as a court can go.
So the court can't declare an elected official unfit to hold an office?
I am not aware of any provision where that could happen.
Do you know the Similani case?
I have heard of the Similani case and I've read it, yes.
Do you know that the court declared him unfit to hold office?
Well, I'm not sure that formed part of the order. I think part of the reasoning said that, but the order itself did not go that far.
So a court can't declare an individual unfit to hold office?
No, I don't think so.
Okay, thank you.
Thank you, Commissioner Malema. Commissioner Nzebeza?
Thank you, Chief Justice. Good evening, Judge.
Good evening, Commissioner Ntsipeza.
Yes. Whilst you were acting at the SCA, did you act at a time when Judge Mhlantla was also a judge in that court?
I did.
And you are aware now that she has been elevated to the Constitutional Court?
I am aware of that, yes.
If the two females who have applied here, who are going to interview, and there are two positions, if they were found to be appointable, would that be a factor for you?
Would that be a factor for me?
For you, for your positions. Two vacancies, two females. One of the positions to be female, to be filled in is a position that was occupied by a female.
Well, I think it's obviously a factor for the Judicial Service Commission to consider. It's not
Yes.
my decision, obviously.
No. I know. That's why I'm canvassing it with you.
Yes.
Yes. Last question. Do you speak any of the African languages?
I don't. I can understand a bit of Zulu, but I don't speak any of the African languages.
Okay, thank you very much. Thank you, Jesus.
Thank you, Commissioner Nzebeza. Commissioner Nyambi?
Thank you, CJ. Do you think judges have a role to play to make the public to understand the role of the courts?
Yes, I certainly do.
How?
Well, I think by writing judgments in a clear way that people can understand, in other words, normal, accessible language. I think judges also are entitled to clarify sometimes the role of courts in a general sense. I don't think judges should try to clarify their own judgments. I don't think that would be right. But to clarify the role of courts and to be part of public fora which explain how courts function and operate.
Share with us your understanding of judicial accountability.
Judges are obviously accountable under the Constitution for fulfilling their duties. And obviously they're accountable to this body by way of disciplinary proceedings. They are accountable to the general public at large to make decisions on matters that come before them and to give judgments as quickly and accurately as they possibly can.
Thank you, CJ.
Thank you. Let me just find out. What if they haven't written a judgment? How do they account? How do you account for your failure to write a judgment? How do you account for taking too long to finalize what could have been finalized expeditiously? How do you account for taking too long to deliver a judgment that ought not to have taken you years to deliver? I'm battling with this concept that it's only through judgments that judges can account. What if the judgment through which you're supposed to account has not been written? And how will it explain your lateness?
That's why there's a Judicial Conduct Committee, which is part of this commission. And I think it's absolutely crucial that judges are held accountable. We are ourselves service providers. We provide the service of dispute resolution in the judicial forum, the court forum, to people who come before us and ask us for a decision. It is unacceptable to delay beyond a reasonable time, given the complexity and other kinds of things of the judgment.
But you know that there are judges, not just in South Africa, but throughout the world, who believe that accountability is irreconcilable with independence. Or are you not aware of that?
I am aware of that. I disagree with that position.
Yes. Thank you. Commissioner Ndoni?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon. Sorry, I can't hear very well. Ah, hello.
That's when I say molo because there is no distinction in Xhosa. Judge, I would like to talk to you about your judgment in the competition law, the Premier Votes versus Manoim.
Yes.
I think you wrote that in early this year. You, in that judgment, you said because Premier was not cited as a respondent, the chairperson of the tribunal could not issue a certification.
Yes.
Would your decision have been different if the leniency applicant was made to sign a consent order?
Yes, a consent order would have entitled the commission, the tribunal, to make it an order of the tribunal, because consent orders under Section 49 allow for that, and therefore the declaration would have been appropriate. Because, remember, Premier was initially cited in the complaint. They simply weren't referred as part of the complaint by the commission to the tribunal. So they were initially part of the complaint.
So the consent order, are you saying the consent order would have been tantamount to a referral? Because if I understand your judgment, you're saying because Premier has not been referred to the tribunal, they could not issue the certificate. So you are saying the consent order would have met the requirement of a referral?
That's correct, because in fact one of the other three parties was also not referred, but did make themselves party to a consent order. And the consent order then gets referred to the commission for it to be made an order, to the tribunal. The commission can't make orders. The commission can enter into consent agreements and then refer them to the tribunal, in which case there is a referral, but only for the purposes of a consent order, not for the hearing as such.
Okay, thank you, Chief Justice.
Thank you, Commissioner Ndoni. Professor Ntlema?
Thank you, CJ, and good evening, Judge.
Good evening.
Can you please share with us your opinion about the tone and the language of the court when it reasons in giving the judgments? For example, the recent Constitutional Court judgment, when it was conceptualizing the concept of the rule of law, it talked about the sword that is ready to chop off the head of the stiffened necks. The Supreme Court of Appeal, in the King's case, talked of a despotic king, which was tyrannical. So how does that language contribute to the fairness of the manner in which the courts deal with the litigants before them? The other question, as somebody, as I understand that you don't have a background on customary law, how is your background going to assist the court in the infusion of customary law into the general framework of the law, in the interpretation of the law?
Well, the first question relates to tone. I think it's very important that when one writes a judgment, that the tone is one which is not hostile without a proper basis for being hostile and using hostile language. I think if one can draw an inference from facts which support the kind of metaphorical use of language that you've given examples of, that might be appropriate. I think courts need to be quite careful, because once a court has said something, particularly if you're the final and apex court, there is no recourse to having that corrected. In lower courts, there is a recourse to having that corrected by way of an appeal. So I think the tone and use of language is of critical importance, so that you're communicating very accurately and with restraint findings which are valid in law and which can be made as a result of the facts placed before you as a judge. As regards the development of customary law, I don't have a background. At the bar, I was involved in a number of cases involving customary law. As with any other branch of law, it is important, particularly since the development of customary law is part of what our Constitution encourages, to make oneself completely at home with those concepts. So one would read widely, one would ask for where to find the relevant aspects of customary law that need to be applied, and one would attempt as much as possible to be sensitive to the customary law context in which you're bringing out a judgment. That happens in all areas of law, actually. The competition law that was earlier talked about was a matter where I was not at all versed in competition law. I had been involved in a single matter in the provincial area which involved competition law, and on a very narrow issue. But one had to read widely, one had to think carefully, and one had to reason in an exact kind of fashion to try to get to the right answer. And I would do exactly that in a customary law matter.
Yes, Prof.
Then will it be appropriate for the court to defer its authority when the matter before it is considered sensitive or political?
To defer its authority. I have expressed myself on the matter of deferring before, which has a separation of powers ring to it. I don't believe that any of the branches of state or organs of state should defer to the others. I believe every one of them must defer to the Constitution. That's the proper deference, is that we will not go beyond what we're entitled to do under the Constitution, and that applies to everybody, including the court.
Well, just to clarify, and it's an unfortunate situation. Some of us can be so firm you won't survive being a member of this commission if you're not careful with your use of words. Should we be tolerable? Should we tolerate the culture of impunity when we deal with it, or when we deal with, say, corruption in general? Should we be soft so that we don't sound too harsh to impunity or corruption as a general concept that we are explaining to people need to be dealt with, and to what end?
Chief Justice, we're not, we're not to be soft. We are to draw very firm lines relating to what is acceptable and unacceptable conduct under the Constitution. There is absolutely no room for manoeuvring or being soft on people who go beyond the powers or simply ignore the powers or the obligations the Constitution places on them. And that's true of everybody.
And of course, even tone must be contextualized. You don't just find a word and run with it, should you?
Absolutely, I think that's quite
Yes.
correct, sir.
I think it's important. Lawyers must do that. Commissioner Fori?
Thank you, Chief Justice. Good evening, Judge.
Good evening, Commissioner.
I assume you've read the comments of the GCB because you've said it's much the same as it was last time round.
I have, yes.
I just want to point you to one or two aspects dealt with by the GCB and hear your comments and, if possible, your assistance. The first is on paragraph 3 on the second page thereof. The question posed is whether the candidate's appointment would help to reflect the racial and gender composition of South Africa, and the GCB says the candidate is a white man. Currently, the Supreme Court of Appeal comprises of 21 permanent judges. 5 are black women, 10 are black men, 1 is a white woman, and 5 are white men. It is apparent, therefore, that while strides have been taken to address racial representativity, gender representativity still lags behind. Given the current composition of the bench, the appointment of a white man will not advance the transformation of the judiciary from a race or gender perspective. That's the one side of the coin. And then if you go further, almost the last page, paragraph 17 and paragraph 18, it says, the candidate would, if appointed, strengthen the SCA not only with a breadth of his legal knowledge and experience, but also with his commitment to constitutional values. And then 18, the message that the candidate's appointment would send to the community at large. The candidate's appointment would send a message to the community that white male judges who show commitment to the values of the Constitution and to substantive justice are valued. Now that's the other side of the coin. My question to you is, taking section 174(2) of the Constitution into consideration, have you got any assistance to offer as to how we marry those two?
I don't believe that they're entirely irreconcilable. Obviously, if one looks simply at what I am by way of gender and race, then clearly looking at me does not contribute to the numbers, as it were, adding up. But I believe that one can make a contribution along those lines in that court by standing alongside of people who may not have had the kind of background and skills that I have, to assist, support, and be collegial towards people who represent a gender different to mine and a race different to mine. And I do believe that a contribution can be made even though I'm a white male. And I do believe that a contribution, otherwise I wouldn't be here, should be made in that way. And I would like to make that contribution.
Thank you, Judge. I'm not going to take it further. Thank you, Chief Judge.
You are all covered, Commissioners. And oh, I'm sorry, Deputy Minister.
Thank you very much, Chief Justice. I only have one question, Judge. There is a term that is being bandied around, and every time there are differences of interpretations, either between the organs of state or the branches of state a constitutional crisis. According to you, what would constitute a constitutional crisis?
A constitutional crisis would be constituted by people deciding that they would, in a systematic fashion, act outside of the Constitution and taking charge of things generally by way of probably by way of force, I would think. So a crisis of the Constitution is when people simply ignore and can afford to ignore by way of the position they occupy and the power that they occupy, where they say, we are no longer subject to the Constitution and we're basically abolishing any need to defer to it.
Commissioner Singh?
Thank you very much, CJ. Just a short question. Good evening, Judge.
Good
Gorven.
evening, Commissioner.
I note that you've had just over 37 years of legal experience, starting as a public prosecutor, 20 years as an advocate. But my question relates to your High Court appointment, which
Yes.
is about 7.5 years.
Yes.
1.25, 15 months being at the SCA in acting. What would you say to the experience vis-a-vis your qualification for an SCA appointment at the High Court level?
Well, I've been very fortunate, even at the bar, to have had a very wide general practice in most areas of the law. And I've been fortunate on the bench also to have a wide range of cases that have come before me. I have been involved in a wide range of appeals, applications, trials, and so on. And I've had very fortunate, strong collegial connections on the bench, both in KZN and in the SCA. I'm not quite sure how much further I can go than that. I've also had an opportunity to write judgments which make some sort of contribution to the range of our law, which have been found suitable to be reported, 35 to date.
Thank you.
Thank you. Thank you, Commissioner Singh. Judge Gorven, you're excused.
Thank you very much.
Commissioners, while we prepare for the next candidate, let me just indicate it won't be Judge Lekhodi. He has withdrawn. It will be Judge Mayer.